Hello, friends, colleagues, judges. Welcome to another session of Lunch and Learn with GEO. We have a very interesting presentation today. Thank you for joining us. You're about to learn a new topic if you're not familiar with it, metadata. Every time you do anything electronic is going to show up. Metadata is going to be a relevant portion of your electronic discovery. We are recording, so behave yourselves. So here's the obligatory disclaimer. I'm sure you've seen it before. So we have some housekeeping items that you should be aware of. If you want to ask any questions, use the Zoom chat box. If you want to post to social media, use that hashtag. The next webinar is July 27th on cyber privacy. This is a redo of what we tried to do in May with Dan Cotter, but he was broadcasting from a Starbucks, God knows where, and he ran out of bandwidth, so we ended it, but we're going to redo it. And today we have Jennifer Hisel. She is with a company called ILS. I don't even know what ILS stands for, to tell you the truth, but it's a company that I have engaged in some prior litigation. Most recently, they worked with us on the Boeing case, and they are very proficient in electronic discovery. And the best thing about it, as far as I'm concerned, is they only represent plaintiffs. So they have no conflicts. They only represent plaintiffs. So they are, from our perspective, very plaintiff friendly, of course. So with that, I'm going to stop sharing and ask Jennifer to take the helm.
Thank you, GEO, and thank you all for attending. Hopefully metadata is an interesting topic to you by the time we're done discussing it. Please feel free to ask any questions as we go. We'll go through the slides, talk about some key points, but if we can have an interactive discussion, that's fantastic. So metadata, what it is and why you should care. As GEO said, we look at things from the plaintiff bar perspective. And the biggest thing that plaintiff lawyers need to do is to tell their client's story. And the story is made up of facts, impressions, events, writings, information, experiences, all these things that come together to tell the story. And in different people, or we call them custodians, usually witnesses, they have a piece of the story that we need to capture and document. And a lot of times that's done not just by testimony, but by data and documents. So as plaintiff lawyers, what we're focused on is telling the story and about finding the evidence to basically promote the story and prove the facts in the case. So I'm sure all of you understand that documents are used in depositions as evidence in trial. And when you look at the face of a document, and where this all really started with e-discovery is paper. You have paper, it can be stapled together, it can be in folders, it can be in boxes. And back when I first started practicing, that's how discovery was done. So I just totally aged and dated myself. But the reality is from there, what e-discovery tools were built to do was work with scanned paper documents. So you'd have a scanned image of a document. And for attorneys to be able to use them effectively to search and organize and attach them to certain custodians, e-discovery software was really built on the premise that we had paper, it was scanned, how do we make it searchable? And back then they would do this thing called OCR, which is optical character recognition, and then load it to a database. And attorneys could actually access the documents that are relevant in the case from wherever, usually at that point it was within the firm. And then as the practice grew, the e-discovery practice grew, there were ways to do that over the internet, right? So you could collaborate with other firms and you could access from wherever you were and have people manage this for you. So back then, metadata came from where the document, the paper document was stored. If it was in a file, you would create a name when you scanned it in that would say potentially the custodian's name. This is in file ABC, and it was collected on such and such date. And those were important bits of information, but they were captured only in the file name. And then, of course, Bates numbers, right, would be stamped on hard copies back then. So Bates numbers are actually another metadata field. Now let's go fast forward to where we are currently and where we've been over the last 20 years progressing to. When we think of metadata now, those same concepts come into play, right? To give us the information about a document or data that's not on the face of the document. So it's information that's created by our computers or our devices as we use them. It's data about data, basically. And obviously, these things are really important when you're trying to represent your client, regardless of what side of the fence you're on, plaintiffs and defendants, right? You need to know the details about the documents that have the important information. And that's how you tell your client's story. So really, this image is to show if you're kind of valuing the data, the metadata is the biggest chunk, and it's underwater, and you have to make sure that you bubble it up. Some common metadata fields. And this, if you think of emails, that's, I think, the easiest way to understand metadata is when was the email created and or sent? Who drafted the email? Who's the author? And that would be sort of the from field, right? And then who was it sent to? So you have to, from, CC, and BCC. All of those are important metadata fields that give us information. The subject line. If we're talking about documents that aren't emails, Word documents, PowerPoints, PDFs, we can get into so many different types of documents, but there's a field that's embedded in every kind of document that says what type it is. Text. So the actual text on a document is a metadata field. It's called the full searchable text. And back in the days, like if you're extracting text from a document, you actually have a field now that's called a searchable text field. So that's how basically things are plugged into an e-discovery review platform. So lawyers can log in and use the search functionality that comes with the platforms. Then things like last modified date, last access date, message ID. Dates are critical. And I will tell you, a couple of years ago during the Pinnacle trial, one of the attorneys, things are coming up in trial that we need to go back to the database and find. And one of the lead attorneys like, what's the date of this? So you go back to the database and you look at the date fields. And what's interesting is something like a PowerPoint where an admin in your firm creates a PowerPoint template, similar to what I'm using here, right? With the ILS kind of branding on it. So this template was probably created 10 years ago, or hopefully our marketing is a little more current than that, but it was created by somebody that isn't me. And if you look at the metadata field, it's going to say author, that person, and it's going to say the date they created this PowerPoint. But I've been updating it for this presentation up until yesterday, basically, and that the other metadata fields that need to be captured now are that I'm the last person to modify it and that I modified it on this date. Because what's important is not, that this template was created 10 years ago. What's important is the content and when that content came forward and by who, when you're talking about litigation. So even like, you down the trial, these dates become super important so that they can plug it into their story or even first see how important it is. Because sometimes things happen at a time where if it would have happened at a different time, it's super important, right? But if it happened at a different time, it's not really relevant to the case. So just to kind of give you a perspective here about what fields you'll see. Here's what we were just talking about: created by, modified by, and accessed. All of these fields are metadata fields that that can be produced to you or that you can produce to the other side.
So how does an individual get to that screen?
So right here, you're going to tab the properties on your computer and then hit general.
On the document itself, on the
Correct.
okay, there's at the top, if you look at any Word document at the top left-hand side where it says file, you scroll down and it will give you is it information? The information tab, I think.
This one is properties.
Okay.
And that's a good point. Every file type is different.
But just for a Word document, then that's where you could find it.
That's right.
Okay.
Yes.
And if I could, would you unshare your screen for a minute?
Sure.
I want to break this down to a basic so that people could understand. And let me share my screen.
I just stopped. There you go.
All right. All right, this is the email that y'all got for today's presentation. Whoop, I just put it away. All right. If you look, this is the email that I sent. If you look up here, it says file, and you go down here to properties, you end up with this set of screens for properties. And this will give you the information that you're looking for relative to this email. The contacts that were saved, the internet headers, and this is important because this gives you the trail of how it was sent, but this tells you when and how it was sent. But in order to get this, you need to have the original email. If you just get a printed copy of this email, you do not get that information. So in order for you to get this information, you have to ask for the email in the original native format. And then when you get it, I forgot the file format that's in, Jennifer.
MSG.
Thank you.
PST.
PST is the one I was thinking about. You have to be able to read it. So if you don't have Outlook or the program that email was sent from, you're not going to be able to read it. But at least this gives you an idea how to dig it out. I'm sorry, you go back to sharing, Jennifer.
No.
I'm sorry.
Definitely. No, I appreciate it and great points. Let me reshare here. Share screen. Please keep weighing in, and we are going to get into a discussion of native versus TIFF, which GEO was just alluding to. So when you're making a discovery request, and for some of the judges on the call here, I love the opportunity to kind of bounce this off of you because you're the ones that are going to be making these decisions, right? Whether council gets natives or TIFFs or if there's a dispute about it, but hopefully they meet and confer and figure it out. But what happens is the parties negotiate over metadata fields. And where it gets really complicated is it's pretty straightforward with emails and Word documents and PowerPoints and your typical standard kind of documents. And we'll talk about why there's reasons natives are really important with Word documents as we kind of go through these slides here. But each side has a duty to preserve the metadata and the data that's going to be relevant to the case or responsive to the case. And so systematically pulling this, so preserving it, then collecting it in a way that those dates aren't changed. Because what happens is if you don't use a forensically sound way of collecting this information, those dates change. And that's one of the most common things we see. And then there's no dates that you can really reference. The date modified means nothing. It means the day somebody collected it, not the day somebody drafted that PowerPoint, which could be very material to the case. So this is a really big deal because it leads to spoliation. And I would argue, not knowing the date that something was in play could be catastrophic to a case. So anyway, that's what these fields, these are samples, but like I said, every different kind of data source has different fields, and this is not even all the fields. I mean, there's more that you can get, and there's some standard ones that people typically negotiate over, and others that just never make their way into e-discovery. So some fields that are typical: file path, so where somebody stored that information. And being on the plaintiff side, this is a treasure trove for us of information.
Absolutely.
So I'm not going to get into the complications of deduplication and things like that right now, but file path is king. Whether there's comments, if there's hidden text, all these things can be pulled out and requested as metadata fields and provided to you.
And depending on the documents that you're looking at.
Track changes.
Yes, that's right. So, and I've got an example a little bit later that'll show you about track changes, how important that can be. Now, beyond what you negotiate for during the e-discovery protocol phase, and GEO, do I need to talk about what an e-discovery protocol is?
It's probably, yes, you probably have to just mention what it is.
Okay. So all of these things about how each side is going to produce information to each other from electronically stored information is negotiated. And there's like a 5-6 page protocol that has what fields are going to be included, well, what format the documents are going to be in. It gets pretty complex, deduplication, hash values, things like that. But the reality is you come up with an agreement, and that's what you live with through the litigation. There are a lot of times that people don't do that, and then they get a production from the other side, and it's something that's not workable or usable in an e-discovery platform.
Hey,
and they're not.
Excuse me, Winslow, would you mind, is it okay if we shared ILS's draft protocol, form protocol?
You and I
Sure.
were thinking the same thing. I was actually going to ask you if it was okay to send that out.
Yeah, would you just,
everybody.
just drop it in the chat line.
Okay, and I've got a couple other documents that we would share too.
Okay, just drop them in the chat line.
Okay.
And I'm kind of digressing by talking about the protocol, but the point is all of these things are negotiated for. So no questions. Okay. So how can we use these types of information, right? Well, with processing, we need to actually take what's produced and create this parent-child relationship. So emails and attachments. We work with the Bates numbers. So the defendants produce documents, they have Bates numbers, that's a field, a metadata field, and that Bates number carries through the entire litigation. The custodian name carries
Jennifer,
through
we
the
have a
entire...
couple of questions when you get a minute.
Okay.
One is from Michael. He says, is there a way to tell what is the original document? I think that was from earlier. And then we have Stephen Comey asked GEO, when does duty to preserve arise? And I'm going to be sending you a preservation example of what we use, included what GEO told me to send you. Sometimes a case is not filed for more than 7 years. Most notebooks are gone.
Right. Stephen Comey, to answer your question about when the duty arises, if you know you're going to be involved in litigation, I would urge you to send out a preservation letter immediately, both to your client and to the other side. Put them on notice that there's going to be a lawsuit, and put them on notice that they now have a duty to preserve. So whenever, as far as your client is concerned, as soon as your client knows that it's going to be involved in litigation, the duty to preserve begins.
Yep. Perfect. And then in terms of if you know if it's a native or a TIFF has a file extension. It's basically a picture. It's an image where the native document would have the file extension or the type of document field that is like PowerPoint or Word. And then what our technical team does is they create that field in our database so you can easily see what type of document it is. And there's viewers, and there's basically tabs you can click on. So if you have TIFF images, you've got an image viewer. If you've got a native document, you click the other tab and you see the native. And one of the cool things about natives is that you can search within a native for words. It gets very frustrating when you have to do it the other way and you have a TIFF image and you have that extracted text field and you're searching in a text field, but you can't see where it correlates with the image. And I've got an example of this coming up. So we'll circle back and you can actually see what I'm talking about. So how do we use metadata? All these things that we asked for and we said the defendants had to produce and we've produced to the defendants, how do we use it? We start piecing together the story here. We can use the date field and we can look at things from a chronological order. We can see, we're looking at emails and the tos and the froms, and we can see, well, wait a minute, why is this person mentioned in all of these emails, but we don't have them as a custodian, right? This person seemed to be in the thick of it. So you look at those fields and determine who was talking to who was emailing who and when. And that's how you can start drilling down by who the key people are and if you're missing anybody. You know, in terms of depositions, authentication, you're getting these things into as exhibits, you're getting them in as they testify. The dates, which we already talked about, and I probably will talk about it 3 more times because they're so important. Some of this other hash values, that's something that goes into deduplication and kind of like a fingerprint of a document. So that's for our technical team. They need those hash values to do their job. And so this slide, I think, is interesting because so far we've been talking about documents. We've been talking about emails, PowerPoints, Word documents, and the metadata there is the lion's share of what we work with. But times are changing and there are so many new ways for people to communicate, and there are so many computers on basically every device, right? As well as automobiles, planes, buses, and literally every day capturing that metadata and then analyzing it for a certain purpose to assess risk, see if the bus fleet is speeding, when there's an automobile crash or plane crash. All of the computers in the car and in the airplane have been capturing data. So it's kind of a different kind of metadata than what we've been talking about attached to documents, but it's really important, especially for plaintiff lawyers, because what we're running into is now defendants, corporations are asking for our clients' metadata, our clients' devices. Were they texting at the time that they had the accident? You know, were they speeding? All these things now are getting flipped, let alone the social media, emails from our clients, all of that type of thing. So that's why I think it just starts to build out the importance of metadata. More benefits, basically, I think we talked a little bit about this. If we're trying to see who's talking to who and when, a gap analysis is, as defendants are producing documents to us, they typically do it in a rolling way. So you get a chunk of documents from one custodian and then more documents and then another. We call those production volumes. So every week or so, they'll give you, thousands of documents and then our team loads them up. But what happens sometimes is they miss something. So those metadata fields let us be able to do a gap analysis, which is validate that we're getting what we're supposed to be getting and that it matches what that ESI protocol said we're supposed to get. So back to the question, how do we know if it's the original document? How do we know if it's a native? You check it against the protocol. If you're supposed to get natives for certain kinds of documents, which I would say like Excel spreadsheets and Word documents are the most common. You use these metadata fields to make sure, to keep everybody honest, to make sure they're doing it right and you're getting what you're supposed to. This graph makes my head hurt, so we're not going to spend much time on it. But I think the point is it just keeps growing and expanding, the communications, the data, and all of these things can be captured because metadata is being created whenever you use your cell phone.
Jennifer, this type of tree, we used it in the case we had against State Farm. We collected all of the phone calls, all of the emails, all of the correspondence, and we put it into a separate software system that created a tree like this. And as a result, and it was the same software that the NSA used to identify who the linchpins were for the 9/11 attacks. When they collected all of the data from different sources, it all came back to Abu Dhabi or whatever his name was as the leader of the attack. Well, we did the same thing and created basically a connection in a RICO case, how everybody was communicating to create the cause of action. This stuff is totally invaluable.
And it's all based on metadata.
Exactly.
That's what you plug in and then it creates the visual for you from it. So the sky's really the limit here. And I just kind of off topic because this actually is happening in real time. So it was before we put this slideshow together, but another use of metadata, it's a case we're working on now with social media victims. And what is so powerful about this, it's data that's being collected from the plaintiff's children. So basically the victim, there's suicides, there's multiple kinds of damages, but what we're seeing is the metadata on how long they were on certain social media sites like TikTok, Instagram, Facebook, whatever the site was. And we're able to capture what videos or what content and how long they stayed on that content, what hours of the night they were on it. And all of those metadata fields are being captured from our own clients' devices and put into a similar kind of a graph like that. And that is going to eventually be used to either figure out which cases are the ones that they want to use as bellwethers, or really is substantive evidence in the case that this is the kind of content that these kids were driven to by the algorithms. So it sort of blows my mind, that you can get to that level of being able to pull the information from a teenager's social media usage in a forensically sound way, and then compile it, put it into a graph so you can understand it, and even dig down to the actual URLs to the videos they were watching. So, all right, now let me circle back.
Somebody is always watching you.
Yes, yes. Now, when we do collections in a normal litigation, forensic collection means we don't change the metadata. That's really what it means. There are forensic examinations. So if you're talking about somebody inappropriately used their computer for something, that's a different kind of a story. It's not as they're looking at Slack space, they're looking at everything that they can do to report how somebody used this computer. That's not what we do. That's not what we did in the opioid litigation. That's not what we do with our own clients' collection. You do a targeted collection of the data that's likely to be responsive, and you do it in a way that you don't change anything. That's it. So, and maybe you all have experienced this where your client just wants to send everything to you. Hey, I'll email you it, right? Well, if they do that, they changed a metadata field. last modified, the date field. So what you need to do is say, wait, we'll get it. You point us to it and we'll collect it from you. And you use software that doesn't change the metadata fields and you're good to go.
That's why if your opponent is, or you take emails that your client sent you, and then you forward them to the other side, you just now changed the metadata. It doesn't help you, or it doesn't help either side. It actually hurts, it actually messes things up. So if you're going to produce things, you have to be able to produce them. What's the right phrase, Jennifer?
In a forensically sound methodology.
There you go.
Which is just means don't change anything. So it's like the bloody knife, right? That's what I always use. Don't pick up that bloody knife. Let the person that has the fingerprint kit do it and document every step of it. So that's really what it is. And for the person that asked about preservation, an interesting thing with social media. So for the plaintiff lawyers out there, like in the Jewel case, they are collecting, or they're demanding all the plaintiff's social media sources. So you can't tell someone to change it or delete it, but you can have them go private. That's fine. And what having your client go private do is, the defense firms have folks scouring the internet. I forget what they call it, open source. They scour everything they can find about you and create these reports for counsel. And then they decide who they want to put up for a bellwether. So plaintiff lawyers started doing that, right? So now we're on equal footing with them, that we know what our clients have out there, which can be really damning if you don't know what's coming. So, but by going private, you stop that sort of sneak peek into who you are, and you're fine within the rules. Okay. We talked a little about this. How do I get defendants to produce it? I know that I want it. I know that it's useful. And really, the rule is, in the usual course of business, how you maintain your documents. It never works that way. It's a battle all the time. And, sometimes you'll get some documents this way. So the ESI protocol is where everything's hashed out and the negotiations documented. And then that's what, the people that are helping you, any consultants or vendors you use, they live by that protocol for you, and they make sure everything comes and goes according to that. So here's I think our obligatory case law here is that you have the right to metadata, basically. And this is a case involving the government, but you have the right to basically, if you have static images, which remember started from paper documents, that's where it all started, static images. You have the right to get the metadata, because that is just as much, if not more, evidence than the static images. So ask for it. It should be a slam dunk. Natives, and here's where GEO was taking us a little bit earlier. Demand natives, and this is why. You can search natives. You cannot search a TIFF image. So natives give you that exact context, and you can see where words and things are, the color, the track changes, all the things that make a document come out of a native. Where you'll see pushback is that it's different, right? It's like, we've been doing it this way forever and ever. True. How are we going to handle Bates numbers? Well, how you handle Bates numbers is you put it in the file name. And sometimes you can do slip sheets. And when it's a document that's going to go as an exhibit in a depot, you just put brand it with a Bates number, if that makes everybody happy. But it's like you're dealing with the actual key documents at that point, not everything that requires people to look at and search through. You'll hear that that's expensive. Well, it's actually cheaper. And, I think the way people explain it to judges makes it so a judge doesn't stand a chance of understanding it unless they kind of have the basics, because the easy way, I guess, to explain it is a native document is a native document. It's the size that it is. When you switch and you make something a TIFF, now you've got the image, which is actually bigger than the native from a gigabyte perspective or megabyte. And you have to add on all that extracted text and all the extracted metadata information. And you do it in this thing called a load file. So it's like TIFF plus plus. So now you've just added tons of girth to what your production is. And most e-discovery companies, if not all, I mean, we do, you charge by the gigabyte size. So by getting TIFFs and all this extra, you're just basically, your client's paying more on top of all the other reasons. So, and I think, we push for natives all the time. We usually get some natives, but TIFFs are still ruling the world.
Hey, Jen, can
All
I
right.
do this one? Can I
Sure.
do this letter?
Absolutely.
All right, so just to kind of put it in the real world for you, this is Winslow from ILS. This is a letter, a real letter that we sanitized and changed it to Acme Designs, and we changed the names around to protect the innocent and the guilty. But it's an offer letter of $78,000 to a new incoming female employee that they're hiring. And this is the TIFF. This could be the PDF. This is a picture of the document. Looks very innocuous, shouldn't be a problem. But in this matter, our client said, no, that's not what happened. There's a much more to it. So we got the native document and looked at it deeper. And what you have are the track changes. Now, the track changes are Kevin in red, who's the big boss, and Roland in green, who's the HR guy. And Kevin is saying, do what you want, but don't bring any more women applicants to this job again. And I'm going to watch her like a hawk. We're not starting a female out at 78K. Click, track change. He changes it to 65,000. Roland says, sir, I already verbally offered 78K. Besides, that's the starting for level 2s. I can't change this. Boom, he makes the change anyway. Same issue. She's recently married, probably going to have a bunch of kids. In fact, the whole decision is against my better judgment. When you show that to a jury or a judge, or just blow it up real big in court, that right there was the end of the story. This was egregious, and it really made a huge difference. And those track changes were never meant to see the light of day. And if you don't have the native, you don't get that sort of thing. It's not just track changes, but this is a great example. And I'll turn it back over to Geo and Jennifer.
Thanks, Winslow. While we're kind of paused here, are there any other questions pending or?
Judge Camille has a question.
Please
Judge
send me the
Camille has-
PowerPoint and then the recording. We're going to do that. Are there not ways to make non-native documents look as if they are native? Is that where
Yes.
you get TIFF plus, maybe is what they're talking about?
Color. So if you get a colored TIFF, it'll look like a native some of the time, depending on the formatting. And let me jump ahead. If it's a simple document, it can potentially look similar. Here's oh good, it's the next thing. Here's an example of it's kind of an example, but yes, this is extracted text, meaning there's a TIFF image and this there's no native. So here you see, if you search, this is where you can search. And if you search a database and you look for the words or the phrase emergency brake, you can then say, okay, out of 10,000 documents, 1,000 documents have emergency brake in them. Then you go to the document, and I'll just jump ahead. And this is the native. There's emergency brake, right? And that's, if I'm searching through a native, this is what I would see. Now I'm going to back up. This is the extracted text for the searchable piece, because if I looked at a TIFF image of this, it would look like this, but it wouldn't be searchable at all. So I would have to figure out where this lined up on the TIFF image. And when you're talking about documents that are sometimes hundreds and hundreds of pages, and it gets very difficult to match up where you can search and what your document looks like. And you lose all the context, right? I mean, this document, this means nothing to you. But when you look at, sorry, I'm clicking around. When you look at this, it tells the complete story and context. So that's just another example. This is a comparison of, which is funny because gas prices would never be this right now, but native on the little side of the gas, like the diesel side for the TIF, I guess, and the regular gas over here, but TIF is more expensive. And I have a sneaking suspicion that, people have made a lot of money over the years billing lawyers on a per gigabyte basis and upping the gigabytes. And that's the reality. And I think one of the reasons why it's been slow to change.
I have a case site in which the judge criticized the lawyers for producing things in TIFF format and said that it's not an efficient way of producing.
Yeah. And it's just still boggles my mind, GEO, that almost every case we end up with landing on TIFFs. It's maybe people know it, and the tools have been built to deal with it. But I'm hoping in the next years, the pendulum swings the other way for all of us. So when we get this metadata and we get these documents and we talked about whether they're natives or they're TIFFs, what happens is it's all put in a database. And from there, you can search it. You can search the text of the documents by the time we're done processing it. And you can search each metadata field. So you can kind of mix and match and really key in on what you're looking for. The other thing you can do is add in analytics, artificial intelligence, and train the system so that it bubbles up the hot documents or the documents that support your story without lawyers having to go through every single document, kind of ranks it for you. So you have all this functionality to move faster, to be better, to if you got a data dump or a big corporation just dumped terabytes of data on you, you don't even know where to start, right?
It's really important in large production cases. I can't say it enough. In a big production case, this is very important.
So, Judge, they'll say, oh, we produce 20 million documents and 40 million pages. And that actually makes it harder for the plaintiff to find where that needle is in the haystack. So that's when you start using artificial intelligence to help you out. More is not always better. And so if you've never seen what a litigation database looks like, this is kind of just a sample type thing. There's metadata fields that are called out here. This is like a document, the different viewers that I told you. And then attorneys go through and code these for different types of things. Plaintiffs are big on coding for issues, themes of the case. You can also write your notes here, and anything that you write as a comment about this document becomes a metadata field. And we can search on it, and we could pull reports for you. So gone are the days when associates would have to do batch summaries. You gave an associate 1,000 documents and they'd have to type up a summary. Now, as they're going, they tag it, make their comments, and we can pull any kind of report you want based on what this document had to do with the case or not. So defendants, while they do that, I'm sure they do the same kind of issue kind of coding. The big thing that they first worry about is it even a responsive document? And I know GEO can tell us about TAR and how that sort of factors in, but let's just say they're making that call. Is it responsive? And if it is responsive, is there any kind of privilege or confidentiality that we need to mark on here and note on here, or withhold it or redact? So plaintiffs, unless they're producing their own clients' documents, are dealing with it in a different way than defendants. So that's kind of what it looks like at a glance.
Then go back to the coding page a second. by doing this, we could break it down into witnesses. Like Jennifer suggested, you could tag it with issues. You could tag it for witnesses. You could set it up for a witness deposition, and you could basically create subfolders through searches. So if I identify 100 documents for Jennifer in a lawsuit, when it's time for Jennifer's deposition, I could call up all 100 documents and create a separate folder just for Jennifer's deposition.
Yeah, it makes it really convenient to do. And then if there's multiple people working on the case, you have everybody's work product in the same place. You can check to make sure people are sort of on the same page. When you get into some of the deep science and technical stuff, mechanical.
Oh yeah, because at the bottom right-hand corner, there's a section for comments. So you can add a comment in there. It says, save this for trial, use this for closing argument, whatever you want to put in there as a comment once you're reviewing the documents.
Yep, exactly. And this is all customizable. So however your way of thinking is, maybe you want to rank, this is super hot, not relevant, and the not relevant ones kind of go off to the side. But that's how that's used. And then the idea is you work faster, you can handle more, you get sort of to the end zone faster, you get past motions, and just kind of keep going over those hurdles that you have to do through the litigation process till you have depositions, you're in trial, and it's all there because metadata let you organize it and search it. I think that is metadata in a nutshell, but any questions?
I wanted to clarify something, Jennifer, because it might help the group too. Even a really important photograph can have metadata on the back of it, correct? That'll tell you like where it was taken, what camera took it, that kind of stuff as part of its metadata.
Yeah, it's embedded if you grab it. So that's the piece. You have to have somebody that knows how to get that metadata that's embedded in it and not just email it to somebody. But yeah, cameras definitely have, because they have Wi-Fi now,
social media, social media.
Well, the reason we had one where the GPS was able to say where they took the picture, which was really important.
Oh yeah.
Exactly where they took it, very close within inches or feet or whatever, exactly where they took it.
Okay.
Any questions about social media? Because that's been quite a bear to tackle on our end from a technical perspective, collecting that kind of information and making it reviewable for lawyers. Has anybody had to deal with that yet?
Steve Comey has. Tell us about it, Steve.
Well, in the most recent,
You muted yourself.
He's on mute.
Steve, you're muted.
in this most recent trial in Wisconsin versus Eaton, the state objected to admission of the defendant's pictures of his front porch with the frozen ice and the logs on the porch, and the state demanded metadata. Judge said, no, the case law doesn't require it. It's not necessary for admission. All you have to do is have the photograph truly and accurately reflect the photograph that's being offered, and that the witness's testimony as to when it was taken is sufficient. So we have a whole lot of law on photographs already. That's appellate law that says what's admissible, and of course, Illinois rules of evidence on authentication are there.
Well, let me digress on that a second. If it's an electronic format, it still has to. You still have to qualify it under 902. So you can raise an objection based on 902 if it's an electronic format.
Well, but it was reduced to a piece of paper when I was offering it. So it had been, copied on colored paper.
Well, I think you got away with something, Steve.
Well, that's the nature of trial practice, isn't it?
Yes, it is. Any other questions?
Well, going back to social media, I've had cases where orders of protection and so forth, where the complainant has sent out various items of social media. The problem generally is, how do you get them from Palo Alto, California? Because they will not honor Illinois subpoenas for the social media. So virtually you have to get the phone of the person you're dealing with in order to get the data that you need. And that's really true of also the text messages, because they will not honor, Google will not honor subpoenas unless the court orders them as virtually a warrant, through the
Well-
warrant, and then coming through the law enforcement portal.
You know, what I've been doing lately, Steve, on text messages, especially for my clients, is I'm having a professional download them all. And then getting from that professional, getting a 902.11 affidavit that says they downloaded everything, and this is these file or this printout, it contains all of the information about that text, and I include in that the metadata of the text so that we could make sure that they're authenticated. And when I compare that with what the other side is producing, the other side's producing incomplete text messages, and they're missing everything else. And it stands out. So I would recommend, if you do that, make sure you have a professional like ILS download the text, all of the text messages for you.
And we have another question, Jen, from Michael. It says, how do you collect social media in the native format?
So how we do it is we collect it for our own clients or our clients' clients, and they give us their passwords. So it's trying to get passwords from teenagers in the jewel case for all their social media. I mean, a lot of them checked out. It's just not worth it for them. So we have this whole delicacy thing of how we handle them and work with the lawyers. But it's, you log in, and then there's a download capability there where you can pull your whole, basically your whole profile out. Where it gets tricky is, and by the way, if someone's public, we can scrape them. We do what's called a web scrape, and we can scrape everything. But where it gets tricky is the format that we can download it in from Facebook is their format. It's not meant for lawyers to do doc review. So if you can imagine, it's not just a post, it's somebody's comment and somebody's comment to somebody's comment, and then somebody posts a picture and an emoji, and it goes on. So trying to parse that together so a lawyer can make a decision about whether it's relevant to the case or not, and they need to produce it, is been a struggle. But there's tools out there we use now that, a little bit ahead of the game. So people were thinking that this was coming. And then the other piece is, do you know, like the direct messages? So those are tricky too, because those are at least a little easier to quantify, more like text messages, but you'll see back and forth, and then somebody's added, and then somebody drops. So all of that has to be captured. The metadata is who's in and out of these conversations, as well as what the conversation was about. So that kept us up at night for a while, a couple years ago, and I think we've got our arms around it now. But as plaintiffs, we fight back on that, and hopefully you end up just having to collect it for bellwether cases, and not for all thousands of plaintiffs in mass tort litigation. I think it's interesting. Oh, go ahead.
No, I'm just, it's complicated. There is no easy answer to that question. That's the only thing I was going to say, because it also depends on the original source of the information.
Yeah. And so the more like Slack and any other app, WhatsApp, all of those things, the Cobb County law enforcement, when we were doing the opioid case for Cobb County, that they were using WhatsApp. So it added a whole new complexity to what we had to collect. It wasn't just emails, right? To show how they're battling the opioid epidemic. And some of the most compelling evidence is their conversations at the scene where, oh my God, you're seeing what you're seeing and coming across and having to do. And you just want that stuff to bubble up to a jury one day. So this was sort of 101 metadata, but think of metadata being everywhere.
So maybe we should start it out like that. All right.
Yeah.
Thank you.
I put my
Jennifer?
contact information. If anybody needs anything, you can always call GEO. He knows how to reach me, but I put my email direct number because sometimes Jen will be off in major projects where I have to wait to reach her later. We appreciate y'all and great job, Jen.
Thank you. Thanks everybody for attending.
Thank you both.
Bye, Geo.
for
Thank you.
participating. And we're going to stop the recording now.